racists just go ahead and be racist. So this doesn't change any of that. What it actually does instead is allow people of color to co-opt and reappropriate language in a way where we get to control our own identities.
7 years ago, the gentleman whose voice you just heard at the top of the podcast, Simon Tam, was rejected in his application to register the name The Slants with the United States Patent and Trademark Office. That meant that no matter how big the Slants might one day get, any other band could name themselves the same name, and any sort of street urchin anywhere could slap Slants on a t-shirt or a coffee mug and sell it out from under them, and they'd have absolutely no rights to it whatsoever. The Slants, whose members are all Asian American, admittedly chose the name because it is a racist slur for Asians. Their intention was to put a new spin on the word. They wanted to use the cliche, they wanted to empower the word and use it to their own benefit. And by the way, if anyone out there thinks that Derek and I should not use the term slants because it's a racial slur, too bad. We're trying to do a podcast here, and I'm not sure I can articulate the difference between slants and the N-word, but there's a difference, and I'm just going to go with saying slants. You with me, Derek?
Turn the volume down if you don't want to hear slants.
Right. Anyway, the Patent and Trademark Office declined his his registration under its rule, which forbids the issuance of trademarks that are, quote, scandalous, immoral, or disparaging. The Slants appealed, and 7 long years later, won an outright victory in the United States Supreme Court. But Derek, what kind of Pandora's box have we opened here? Free speech is essential to a thriving democracy. I think we all agree the Slants should be able to use the Slants as their name and trademark it. But do we really want to live in a world in which hate groups can get the exclusive legal rights to the N-word in certain contexts? Or an anti-gay group could get homophobic slurs, slap it on t-shirts, and be able to sell it as they want without anybody else being able to claim that word for themselves? That's a discussion for this week's episode. I'm Jason Beckerman.
And I'm Derek Kaufman.
And this is Behind the Bar. Derek, tell us what we got here. What happened in this case?
So the Supreme Court held in the case that the so-called disparagement clause, this is a rule that's applied by the USPTO to reject certain trademark applications based on them being disparaging to a certain group of people. And they said, look, this is unconstitutional. It violates the First Amendment's guarantee of free speech. So Justice Alito, who wrote the opinion, said, applying this type of criteria to deny trademarks that are offensive to a substantial percentage of people is classic viewpoint discrimination, and that is anathema to the First Amendment. I have a problem with this ruling, though. I actually have 3 problems with this ruling.
Ooh, do tell.
So in reaching the ruling, the Supreme Court dismissed 2 lines of important cases that I see. So one is they call them subsidized speech. This is when the government gives money to certain groups of people, and that money has strings attached to it. So you see this a lot in the National Endowment of the Arts. Sometimes they'll give a cash subsidy to a certain artist to do something for the government, maybe to make a commercial on Sesame Street or so forth. They give them a subsidy for that. And when you're that artist, you're only allowed to express certain viewpoints that the government deems appropriate for children, let's say. So in that context, they are abridging free speech. And to me, it seems the same thing here. Here, the value is not a cash subsidy, but the value given here is a monopoly over a particular term or slogan. So when you go to the trademark office, you're asking the government to stamp its approval, in a sense, on a particular phrase. And in doing so, you are conferring value to them. So in some sense, the government is subsidizing that kind of speech. I think they could have seized on this line of cases and really come out the other way. The other line of cases is called government speech. So that's when the government is actually doing the speaking. And Alito said, look, this doesn't count either. So there's a line of cases where license plates, there's, vanity plates. We have them in California. They have all sorts of comments on them. In Texas.
And there are restrictions on what you can say.
And there's heavy restrictions. In Texas, someone wanted to put a Confederate flag on their license plate, and Texas said, absolutely not.
Right.
These are Texan license plates.
But that's his viewpoint. He says, hey, I have First Amendment right to say what I want to say.
That's right. And that went up to the Supreme Court, and the Supreme Court said, no, this is a category called government speech. When the government is talking on a license plate, we're going to be able to restrict the speech in that manner. Alito says, this is not like a license plate, so he threw those cases out. But the biggest reason, the third reason that I think this case should have come out the other way is you have to remember the Slants are not being denied the right to call themselves the Slants. They could go out as a band and say, we're the Slants. They could announce themselves that way. All they're being denied is a federally registered trademark. They could even invoke a common law trademark if someone else tried to use the name the Slants. All that was denied here was a USPTO person said, this is not appropriate for a federally registered trademark. And so I think that could have been a narrow ground to dismiss this case.
Yeah, I mean, ultimately, and I don't think you're denying this, but this is about whether we as a country, as a people, want the government to tell us what we are allowed to say and what we are not allowed to say. In the case of art, I hear you. It's a little bit strange to have the government, for example, with the National Endowment for the Arts, Sesame Street's a good example, telling us, look, you artist, you're going to get this money, but this other artist who's throwing poop on a wall, he's not going to get this art. He's not going to get this funding. But there, the determination is not what is speech that we want to promote and what is speech we don't want to promote. The determination there is what we consider art. It is not viewpoint discrimination. It is art discrimination. It's the value of the artistic pursuit. If the poop on the wall was a legitimate public commentary and the National Endowment for the Arts found it as such and determined that it was an important part of our government of our public discussion, they would certainly, I think, take it at their word, they would do this. They would fund that artist. But instead, they're trying to make a determination of who's really an artist, who's promoting the arts, and who is simply sort of taking advantage of the government dole and trying to get money from us when they're not actually pursuing an artistic field. I think that's the distinction there. It's not viewpoint discrimination. It's discrimination based on the value of the art. I understand it's hard to tell sometimes.
It's hard. I mean, I think Robert Mapplethorpe would take issue with, is he an artist? He's obviously a very avant-garde sort of artist. I can't imagine the NEA giving Mapplethorpe money. Maybe.
In this day and age, maybe not back when Mapplethorpe was Mapplethorping, but in this day and age, I do think that the Robert Mapplethorpes of the world and the other, Robert Mapplethorpe, who those who don't know, is a very famous photographer. He took many, he sort of was groundbreaking in the photographic art of taking nude photos of women. I don't think men, right? Just women. All right. So, but in today's day and age, I do think he would be okay. We were a little more puritanical 40 years ago when Mapplethorpe was at his zenith, but I think today he would be funded. So I think that's a distinction there. And the license plate thing, I think that the distinction that I can draw, though I think it's a much more difficult case there, the distinction that I can draw is that driving is a privilege. It's not a right. That's one of these old things that we hear all the time. When we apply for the right to get a license, a license plate, we are saying we want the ability to drive, and the government has every right to deny everybody that right to drive. I see it a little more in the form of government speech in this, although I do agree it's a more difficult thing.
I agree with you. Texas is on the license plate.
Texas is on the license. It's a more of a imprimatur of government speech than the case here. I got it. Look, but ultimately here's where I fall. If the USPTO, the United States Patent and Trademark Office, can issue a trademark for Black Lives Matter, and I think we both agree that, barring, assuming all the other factors are present, they could issue a trademark. Sorry, my cord's bothering me. They could issue a trademark for Black Lives Matter. They should also be able to issue the trademark for Black Lives Don't Matter. It's abhorrent. It's offensive. It's hard to hear, but it's not nearly as offensive or abhorrent as the government determining what is heterodox and what is orthodox, what is good speech and what is not good speech. And I wanted to read something that Justice Alito wrote for the court in the 8-0 decision. He said, the idea that the government may restrict speech expressing ideas that offend strikes at the heart of the First Amendment. Speech that demeans on the basis of race, ethnicity, gender, and so on is hateful. But the proudest boast of our free speech traditions is that we protect the freedom to express the thought that we hate. And that's really important. We must protect the thought that we hate, the expression of the thought that we hate, because otherwise the First Amendment is easy. Right? It's easy if all we're doing is allowing speech that we agree with. There wouldn't be a problem. We have to protect the speech that we hate. Now, I'm going to wrap up quickly, but I just want to tell a quick story. What's absurd, I think, of the USPTA's ruling here is that the word "the slants" is only off limits to Asian people. If you think about it. My wife has 4 friends who started a winery called Slant Walk. It's based on the path they took at university from their sorority house to their class. And it was a slanted walk, one of these things. It was slanted, and they called it Slant Walk, and they founded a winery called Slant Walk. And I think you and I would agree that that's a perfectly trademarkable term. The USPTO would have no problem trademarking that term. However, let's say instead that it was a path that the Asian American students took from point A to point B, and it was sort of where everybody knew that the Asian American students were, and it was a play on, same kind of thing it was here. They were taking that term because of the old stereotype of slant eyes, which is where it comes from. Under the USPTO's reasoning, they would not be allowed to trademark the term slant walk, but my wife's friends, who are white, would be able to trademark that term. That's an absurd result that couldn't withstand, I don't think, scrutiny.
Yeah, no, that consistency, I agree with you. You're it's somewhat of a plea for, let's take this out of the hands of these government officials sitting in an office because they're going to reach these sort of inconsistent, absurd results. But there is something to a Potter Stewart approach. I know it when I see it. When you see slant walk done by an all-white group to make fun of the Asian group, you kind of know that's wrong versus the winery example. And so I do have, I think, more trust in government officials, but I think you're right that in some sense that the inconsistency, because I looked up some of these. NWA, the original rap group, their trademark was allowed, but
it's allowed as NWA, not the spelled out word.
Exactly, just NWA. But several years later, Damon Wayans wanted to start a clothing line called N-word with an A at the end. He wanted to start a clothing line. N-I-G-G-A, and he was denied. Queer Eye for the Straight Guy, that show that was on a decade ago, that trademark was approved, but Dykes on Bikes, disapproved.
Right.
So
are we allowed to say that?
It just happened, Jason.
Right.
We've done it. We've done Dykes on Bikes. Their trademark was disapproved. I think under the new regime, you're going to get a much more consistent approach, but we really have opened a Pandora's box.
We have. You took the words right out of my mouth. We have NIGGA, which we all think should be trademarkable by Damon Wayans under the new ruling by the Supreme Court.
Yep.
But the phrase "I hate NIGGA" is equally trademarkable.
Yep.
And we have to accept that, or we have to sort of abandon the whole thing.
That's right. The bitter with the sweet.
We also wanted to get sort of some firsthand knowledge about this, and so we invited, and he was gracious enough to accept, Simon Tam to join us on the podcast.
Thanks so much for having me.
Simon is the founder and the basis of the Slants. Nobody more important to talk to at this moment in time.
Yep.
So, Derek, what do you have for Simon? I know you have some questions lined up.
So Simon, we've read. I read your interview in Rolling Stone. I found it very, very interesting. And you mentioned that your intention in naming the band the Slants was to put a new spin on the term, sort of co-opt it for good. It had been a disparaging term towards Asians in the past, but you were going to sort of take it back and make it sort of a positive thing. I'm interested to hear your take on the Supreme Court's decision, because while you'll now get a federal trademark, there's a bit of a Pandora's box that now that other disparaging terms could be used in a negative sense, and I'm a bit curious what you think of that legacy.
Sure. Well, first of all, disparaging terms have always been used against people of color, whether or not people have had trademark registration. As somebody who's experienced a lot of bullying and racism in my personal life, nobody's ever been like, hold on a second, let me file my application for the trademark office before I use these words against you. The racists just go ahead and be racist. So this doesn't change any of that. What it actually does instead is allow people of color to co-opt and reappropriate language in a way where we get to control our own identities and not, defer that decision to some random examining attorney at the trademark office.
How are you going to feel the first time it comes down where some sort of racist, xenophobic person says, registers the trademark and starts printing off T-shirts, which is, I don't know, I dislike slant-eyed people. You comfortable with that as a natural progression of what you've done?
Again, people have been doing that already for decades.
Yeah, that's right.
So it's not like this changes any of that. People have been using all kinds of denigrating things. And in fact, every single racial slur that you could think of is already a registered trademark at the trademark office.
Oh, is that right? It's kind of like domain names. There's nothing left that people haven't already registered.
Well, this is where one of the big criticisms of the policy we fought against is that the trademark office itself is extremely inconsistent. So every single slur you can think of for Asian Americans actually is already on the books and protected by trademark registration, minting dozens and dozens of trademarks for slant.
Interesting. So one concrete example, though, of a byproduct of this is Dan Snyder. So the Redskins owner trumpeted this as a huge victory that's really going to clear the path for trademarking the Redskins. And I know that a lot of Native Americans take a lot of offense to that. Have you gotten any flack about pushing this lawsuit? Because it was an obvious byproduct that this was going to happen.
Yes, and that's part of the conversation, which I think is really important to have. I think it's really important to have dissenting opinions and other perspectives to see how our laws can have disparate impact on people. But the reality is that Dan Snyder knew this, that his name was never in danger. Just because he had some of his trademark registrations canceled a few years ago, it did not mean he was forced to change the name of the team, its mascots, or anything like that. And because he's built such a great empire, such a powerful empire with that brand, he actually had tremendous protection for his trademarks. So trademark registration actually has this bigger impact on lower income communities,
Right,
who don't necessarily have the resources to build up trademark equity like NFL football teams do.
Speaking of resources, I know this has been a 7-year grind for you. I'm sure tremendous personal expense, and despite the Slants' great success, my guess is that millions haven't flown in to fill your coffers and pay for lawyers. Did you ever get disheartened at any point through this process and say, you know what, it's just not worth it for me to continue to fight this fight?
I've thought about that many, many times, especially in the beginning when I was just kind of faced with all these huge legal bills that were piling up. But at that point, this was when I was working with a different attorney. He told me kind of about the research behind the law we were fighting against and how it was used primarily against communities of color and members of the LGBTQ community. And faced with that, I knew I couldn't walk away no matter what the cost might be. So I picked up a lot of side hustles, got a lot of jobs to foot the bills.
Any good Samaritan lawyers step up and represent you for free at any point along the way?
Thankfully, many have.
Good, yeah.
So my first attorney, Spencer Trowbridge, agreed to take it on pro bono, especially when I was like, this isn't worth it. I want to drop everything. And then when he eventually left and Ron Coleman took over, he did so on pro bono work.
So the next time people disparage us lawyers, you've got to stand up for us and make the truth known.
Yeah, and it was kind of funny because after we'd been fighting this thing for multiple years, as we were kind of going up to the Supreme Court, and it was becoming really evident that that's where it was going, all of a sudden I had dozens and dozens of lawyers appearing out of the woodwork saying, hey, I'll take your case on for free. I'm a Supreme Court specialist.
Yeah.
And even though my attorney and his firm had never been to the Supreme Court before, I was like, this is the guy that showed up many years ago before all of you did, who agreed to do this thing. So I wanted to give him the chance to argue. I believed in him, and I thought that, well, at the end of the day, the truth would win out. And thankfully, it worked out for us.
That's great. I have one more question. So you're bandmates. You're in a band. At any point along the way, were they not as supportive? I mean, this is now going to be something that you guys carry with you for the rest of your career. You're going to be the band that was the center of a Supreme Court case, at least in dorky legal circles like us. That's how I'm always going to think of you.
You're going to have a sweet Wikipedia page.
Yeah, it's going to be thick. It's going to be great.
Yeah.
Yeah, I mean, and that's the beauty of it, that I didn't even have consensus in my band the entire time. There were people who thought, we should just concentrate on the music. We shouldn't be worried about these kind of legal battles. At the end of the day, to some extent, everyone did support it. They just thought the law case was more of a distraction than anything else. The case itself has actually lasted longer than any other member of the band other than myself. So when people came into the project, at least for our last kind of most recent lineup, everyone walked in knowing this was a big part of who we were as a group, that we kind of combine art and activism in everything that we do.
So Simon, before we let you go, I want to give you an opportunity. You've been so great with us. What do you have coming up?
Yeah, where can we see you?
What
CDs?
projects and where we can catch you on tour?
Well, we actually released a new EP earlier this year. It happened to be the same week we went to the Supreme Court.
Oh, perfect timing.
So it was a 5-song EP called The Band Who Must Not Be Named, but I think we need to update that title now. Other than that, we're actually in the studio working on some new music, and we'll be back on the road again later this year, probably late summer, early fall, and kind of added to our mix. Like we've always been known for playing anime and video game conventions, but just this year we started touring and playing law schools and IP law conferences. So probably look for us at some of those.
Well, that's the last place you will find Derek and me, but that's.
But I'm expecting a special power ballad for Justice Alito. I think he's earned your affection.
There we go.
Yes, definitely.
All right, Simon Tam, thanks so much for your help. Everybody go check out The Band Who Must Not Be Named. I'm sure it'll be available on iTunes, right?
Yep.
All right, Simon, thanks so much. Appreciate the time.
All right, thank you.
what a great guy. I mean, this is a guy who put his self-interest aside. I mean, he could have just picked a new band name and just moved on with his life, focused on music, but he put his self-interest aside, and he really seems to care deeply about the impact of this on marginalized groups. I think that's great.
Right. I mean, let's face it. It was a huge personal expense to himself, huge both his time and money. I don't know the Slants. I don't know the band who may not be named. I've listened to them. They sound fantastic, but I'm guessing that this is not purely a commercial enterprise, a commercial endeavor for him, this entire lawsuit trying to secure this name. What he did was he saw a cause, and he said that it's mostly minority communities and the LGBT communities that are injured by this, and saw something that he felt that he had to do, and I give him great credit. I also, plaudits to the lawyers who stepped up and did this for free, but there's huge personal time and monetary commitment to make this thing happen.
Yeah,
So
and kudos to him, too. He's also willing to accept some of the things we tried to press him on, and we said, look, this is going to have some negative impact on the things that we see out there, and he's fully aware of that. It sounds like he's thought deeply about these issues, and he just thinks that freedom of speech trumps those issues.
So before we jump into mail time, really quickly, because we get this question all the time, just wanted to give a quick run-through of how we get from the trial stage, how a case ends up at the Supreme Court. So what happened here was that the USPTO denied the trademark registration for the Slants. The Slants then filed a motion in court because a court can overturn a patent, the patent office's
They're
decision.
just an agency.
They're just a governmental agency. They're just regulators. And if a court comes up and they said this is unconstitutional, the lower court level, I believe, upheld the USPTO's decision. The Court of Appeal for the district in which it was in, and I believe it would happen in Portland. So it's the Ninth Circuit Court of Appeal, which handles the
Federal Circuit,
which handles
it was a federal circuit because it's a trademark, USPTO.
So the Federal Circuit, which is based in Washington, D.C., which oversees much of the intellectual property cases that come up, they said, no, we're going to overturn that lower court decision. We think that the Slants have a First Amendment right to use this name. We think the USPTO overstepped its grounds. It was then appealed to the U.S. Supreme Court. What the U.S. Supreme Court does, it simply looks at the record that was created at the trial court level, looks at the papers, look at any testimony that was given at the trial court level, doesn't accept new testimony. It hears legal arguments only, but it doesn't hear from witnesses. And based upon just the legality of the record below, what exactly the USPTO said in issuing its decision and the lower court said based on the testimony in its decision, it came to a conclusion that the USPTO's denial of this trademark violated the First Amendment.
That's
so
correct.
just a little bit there to sort of round
That
this
puts a fine point on it.
What's that sound?
Sounds like mail time, Parker.
That's right, mail time. Remember to write in your questions and comments to behindthebar@tmz.com. The first one up is from Tabitha. After listening to your podcast on the texting suicide case, I was surprised to see a guilty verdict come down. I wanted to know your guys' thoughts on the verdict as well as what the chances are of an appeal.
We really let you down, Tabitha.
I'm stunned.
We were
I'm
both stunned.
Yeah, we were. Although I think my point was less stunned than you, right? I took the position that I thought that they might get a guilty verdict here.
You did. I was flummoxed.
But even when it came out, I was stunned. So the likelihood of appeal, I think is pretty slim that she will win on appeal. The way this happened was that when she was first indicted, she appealed the indictment up to the higher courts within Massachusetts, and they sided with the indictment. So she basically said, I can't be charged with this at all. And it went up to, I believe, the Massachusetts Supreme Court that said, yes, you can. So the issue of whether it's legal to charge her in the first place, whether or not the jury could even determine guilt or innocence, has already been decided. I don't know the specific issue she might want to appeal on, but based on the general legal principle of whether you can charge someone with this, I think the Massachusetts Supreme Court already decided this.
I'm with you. That fight has been had. Where she is now in the case is really a sufficiency of the evidence type appeal. But
every criminal case has those, and they never win.
Exactly. Those are really uphill battles. You want to defer to juries and judges, and she chose the bench trial. She has to live with the verdict, I think.
Yeah, that's right. I think the next thing we need to look at is what the sentencing is going to be, right? She has not been sentenced yet, to my knowledge, and so we're going to see. I think the judge will be more lenient on her than he might be in the same charge with a different defendant.
I think that's where the difference is going to be made.
All right, next one up is from Mark. Again, an officer has been acquitted for what appears to be a gross unnecessary use of force in the Philando Castile case. Why is it so hard to prosecute a police officer for something they do while they are on duty?
Yeah, so everyone has heard of this case by now, but Philando Castile was pulled over in Minnesota with his girlfriend and his daughter in the backseat, or her daughter in the backseat. He informed the officer that he had a licensed weapon in his pocket, and the officer said, "Don't pull it." He said, "I'm not trying to pull it," and the officer opened fire at that point, killing him.
And now civil verdict.
Oh,
no,
sorry. And now and now the officer was tried and eventually found not guilty of any crime.
That happened last week, and it's really brought on a huge amount of discussion about, just generally speaking, this is the questioner's query is, how can you ever prosecute these cops? Why is it so difficult to prosecute these cops? And I think that the general answer is you really do need to allow police a great deal of latitude in how they conduct themselves. I'm not at all saying it justifies the situation involving Philando Castile, but generally speaking, police have to be given a great deal of latitude. It's a dangerous job out there, no matter how we feel about cops. It's a dangerous job out there. And cops do get killed in the line of duty all the time, and they are on sort of the, on edge at all times, and they can be a little bit more trigger happy. And situations arise where they do accidentally kill innocent people, unarmed people, and even though it was accidental, they didn't mean to do that. It happened, and you can sort of understand how they got there.
Yeah, I mean, look, these are the scariest moments for an officer, especially when you're pulling over a car. They are in a more vulnerable position at that point. The person is still in the car. There can be furtive movements that are misread.
Yeah.
I think even when you see the dash cam footage, as haunting as it is to see him open fire, he looks more like a jittery, perhaps scared officer than one who is acting out of any racial animus at all.
Yeah, but that said, I think it is incredibly hard to justify the shooting in this case. I mean, he was doing, as far as we could tell, nothing wrong. He alerted the officer to the existence of the weapon. I know you've taken big umbrage with the police officer here in his defense of himself, where he said, "Boy, I smelled marijuana, and therefore I figured I was in some sort of danger."
Yeah. I was troubled by that. He said, "I smelled marijuana and saw a young child in the back seat, and I thought I was dealing with someone who could do that. It could be someone who could kill me."
Smoke marijuana around a child is someone who could kill me, which makes absolutely no sense. Yeah. It is hard to, just to go back to the questioner's question, it is hard to imagine how it is that you're going to prosecute a police officer. If this guy can't be convicted, I'm not sure who can.
Yeah.
All right, the last one up is from Amy. In your opinion, what TV show most accurately portrayed what goes on in a courtroom?
Oh, I like this question
a lot.
I love
this. There's been a lot of great TV shows. I'm curious your answer. You've seen probably...
I mean,
what do you think of L.A. Law? That was
L.A.
seminal.
L.A. Law was not realistic at all, and didn't pretend to be realistic. Yeah. You'd have these lawyers standing up and making outrageous speeches to the jury. I think, and none of them are perfect, and you can't because courtroom dramas, real courtroom dramas are boring. Yes. It's only you have to spice them up a little bit. I always thought that I always thought Law and Order did a pretty good job because it dealt with process a lot. And one of the things is, the substance of the trial, where they ask questions and get answers. That's like 1/50th of what actually happens. Yeah. It's all about process, the person being indicted, the appeals from the indictment, going into chambers, having discussions with the judges, keeping certain evidence out while allowing other evidence in. I think that's the most fascinating point, and I think Law and Order did the best job of that.
I agree. Law and Order is still something I watch when I'm homesick. There's just endless episodes. I think the one that doesn't stand up at all, just to answer the inverse of the question, is Perry Mason. I used to watch old episodes of that, and that show has surprise testimony all of the time, and usually a trial is played out theatrically in a way that all the lawyers understand what is going to happen. It's actually designed to have very, very few surprises occur, and you're not allowed to spring things on the other side in quite the way that Perry Mason.
No, your point is absolutely right. If the judge has done his or her job and the lawyers have done their job, there is nothing surprising that comes out. That's the purpose of is not to inflame the jury with surprise testimony. It is to get all of the evidence out, make sure both sides know it, and they put their best foot forward to explain that evidence, and then the jury's allowed to make a determination with all of the evidence at their disposal. The Perry Mason stuff never ever happens. You can have the best lawyers in the world go through 60 years of a career, and they will never have a Perry Mason moment, as it's called.
All right, that is it for Mail Time.
Thanks very much for joining, everybody. We will be back next week once again with a great new episode of Behind the Bar. See ya. Thanks for watching. If you want more nerdy deep dives into the legal side of celebrity news, hit our subscribe button right here.
And check out our previous episode over here.